going to be the oral history of Jerry Mize. We're here in Las Vegas at the Colorado River Water Users Association meeting. It's December 12th, 2001. Jerry, I think most people would think about your involvement in Colorado River matters and think instantly to your involvement in the Arizona-California litigation. Can you tell us how you first became involved in the case?
Well, I guess I'd first say how I happened to be out at Stanford Law School, which is where I met Mike Ely, who got me involved in all this originally. But I'm a Pennsylvanian by basic residency for so many years. My wife and I both are, and we happened to come out to Stanford because a good friend of mine at Princeton ran into Bill Norris, who was a Princeton grad and who had worked for Mike Ely on the Colorado River litigation in the early 50s. And then Bill later came out to California and became a Ninth Circuit judge and is now retired, I think. But anyhow, my wife and I decided to come out west to Stanford, which we did. And I believe it was the summer of between my second and third year at Stanford that Mike Ely came down to interview students for a summer clerk's position with the California Attorney General's office, not with Mike's firm. Mike had been hired by then Attorney General Pat Brown to be special assistant Attorney General to handle the Colorado River case, which Arizona had filed in 1952. And Mike interviewed a number of us, and I was very impressed with Mike, and I was very fascinated with the litigation and with the job of clerking on it. The trial was going to be starting, and this was the summer of '56. I think the trial was going to be starting up in San Francisco that summer, and so I thought this would be an exciting thing to do. And also the pay was pretty good for a state deputy. I think I was called Attorney General, even though I was just a clerk. So I told Mike I was interested, and he hired me. And that summer, we started the trial up in San Francisco in 1956. And I did a lot of the mundane things that summer law clerks do, research and so forth. But I got to meet a lot of the people who stayed throughout the whole litigation. But that's how it all started.
Did you work then in your final year of law school, or did you
just
work in the summer?
After I graduated, Mike then offered me a permanent job with his law firm back in Washington, to be preceded by me working from the beginning of the summer of '57, when the trial was again ongoing up in San Francisco. Mike wanted me to go on the Attorney General's payroll, which I did until I passed the bar in January of '58. Then Mike hired me for his firm. We just stayed, my wife and I stayed out in California. We moved down to Pasadena for a year and then eventually didn't go back to Washington until October of 1958. And then I was a member of Mike's firm and working under the same contract with Pat Brown that Mike had with the state.
Can you tell us a little bit about some of the individuals that were involved? We start with the California folks.
Well, of course, the top individual was Pat Brown, who was a very gregarious Irishman. He used to come through well, first of all, there was a special litigation section set up in the Attorney General's office to handle just the Colorado River litigation. It was headed by Gil Nelson, who was an assistant attorney general. I believe that would have been his title down in LA, and Pat Brown put him in charge of this Colorado River group. But Mike Ely, even though he was a contract special assistant attorney general, was really running the show. I mean, he was in charge, and Gil was a very amiable, pleasant guy. Actually, I recall he was a cousin of Ray Bolger, he told me. And he looked, if you ever knew Gil Nelson, he looked very much like Ray Bolger. But Gil was kind of the nominal head of the office, but Mike was really in charge. That's the way Pat Brown wanted it. Mike hired a number of other outside attorneys to be special assistants. in that unit. The principal one was Charlie Corker, who had been who was a Harvard Law School graduate and had taught at Stanford for a while. And Mike bumped into him somehow in the course of putting this special team together, and he was very impressed with Charlie. And Charlie left the Stanford faculty and went on this case and saw it through the end. Indeed, stayed with the Attorney General's office after Arizona against California was finished in '64 for a while before he went up to the University of Washington to teach at the law school there. Other people that were hired, two I remember, were Howard Friedman. Not sure where Howard came from, but he later became, he didn't stay too long with that special unit. He went to practice with Loeb and Loeb, where I think Melissa's a partner now. And Bert Gindler came in from, and I think responded to an ad in the paper and came in from Minnesota and joined that special unit. Same summer I did, 56. Bert may have preceded me by a little bit. But Bert stayed for the duration also, and then he subsequently went into private practice with Seth Huffstetler and Shirley Huffstetler's firm. I've forgotten what the name was at the time. I think he's still with them in some subsequent firm. Then those were lawyers brought in on a permanent status in the special unit, and other people kind of worked part-time. I think Bill Norris, again, was on a special contract that Mike had with him to help on the case. Shirley Huffstetler became a very integral part of that team, although she wasn't part of the permanent litigation group.
Was she working in the AG's office generally? Or?
No, she was in private practice.
Oh, okay.
But she had a contract with Pat Brown, and it was kind of part-time. We had the trial up in San Francisco, but there was a special office for the Colorado River litigation down in Los Angeles at 9th and Broadway, which I think was actually the headquarters of the Colorado River Board at that time. We were sharing space, or had adjacent space to the Colorado River Board's offices there. There were a couple other young lawyers about my vintage that were hired. One was Andy Chaudhry, who was a native of India and had just graduated from law school back here and was interested in water issues, and he was hired for several years. Then he moved on, went back to India. Harry Sondheim was just hired and worked pretty much for the duration of the litigation. John Alexander was hired as a Department of Justice employee in that special unit and went through the duration of the litigation. And he became, as I recall, a Superior Court judge, maybe municipal court judge in Los Angeles. And there was one other lawyer whose name escapes me who wasn't there too long, but that was kind of it. You had Mike Ely brought in as special counsel to be the head of the team. Gil Nelson, the nominal head of the team and a full-time Department of Justice assistant. And then the special people Mike hired, Charlie Corker, Shirley, the rest of us. And we had titles as we were State Department of Justice employees during that short period until I left and went with Mike's firm. Then I was just acting under the contract Mike had with Pat Brown.
And how did this particular team then interact with the California agencies? All had their general counsels or special counsels, I think, who were also involved in the case.
Well, it was, as I look back, it was rather hard. I think logistically it was hard to coordinate everything. Mike and Charlie Corker, I think, pretty much had that responsibility. Imperial was represented by Harry Horton and by his, I believe, son-in-law, Reggie Knox. Palo Verde was represented by Frank Jenny. Coachella by Earl Redwine. Los Angeles Department of Water and Power by very funny, Gilmore Tillman. And who else would we have?
Metropolitan.
Metropolitan was Jim Cooper. And those were the principal players. They all had their individual personalities. Some were more dynamic and effective than others. I think most of them took Mike Ely's lead. Mike would kind of come out with strategic proposals and so forth, and either by correspondence or on the phone, or in most cases on important matters with actual meeting with all the agency council and work out positions. I suppose I think all of them went along pretty readily. The one who was more independent, and I'd say a little feisty maybe, was Harry Horton, because Harry was Imperial's counsel and was well along in years and quite a reputation, I think, in the state as a water lawyer. So he wouldn't always see eye to eye on things that Mike wanted to do. It may have been that there were tensions then even between Imperial and Metropolitan that I wasn't aware of, so that maybe Harry would see issues lurking in some positions the state was taking that might come back to bite Imperial. And so he was kind of more cautious, and I'd say not as easily not as likely to come along immediately on most of the group's positions as some of the other lawyers.
Since you were sharing space with the Colorado River Board, did the board have much of an influence?
Oh, they were our technical people. Ray Matthews was, I guess, I don't know if he was called executive director then, but he was the equivalent of Jerry Zimmerman at the time. And then the board had a lot of, I think, many more engineers than they do now. They may have beefed up their staff specifically for the litigation. Gil Lee, for example, was one of the engineers. I think Gil later went on to law school and worked for LA Department of Water and Power for a number of years, and maybe he still does, or maybe he's old enough to retire by now. I'd say we all got along very well. There was a lot of camaraderie. They were very helpful. A lot of the engineers were very able. They didn't have to do very difficult things. When we got into developing the water supply phase of the case, Tom Stetson came down on, I think, on assignment or whatever you want to call it, from the Department of Water Resources up in Sacramento, and was assigned to the Arizona against California litigation, became our top expert on water supply, and actually later testified on that issue. And by the way, that was a great part of our case we developed, and the special master ultimately just ignored it completely and said water supply was completely irrelevant to the case, and a great deal of time, effort, and money went down the tubes on that issue.
Did you have other technical experts that were brought in from the outside?
Yes, I think we brought in Raymond Hill, who was an old friend of Mike's and who was a very prominent hydrologist, I guess. He was with a firm, as I recall, Leeds, Hill, and Jewett. Now I see there's a firm called CH2M Hill or whatever, and I assume that Hill is Raymond Hill, although I don't know. But he also testified on water supply, and we never got to know him very much. He was kind of a pompous fellow, and I think Mike Ely told me one time that someone said that Raymond Hill was the only person he ever knew who could strut sitting down. So, which I thought was an apt characterization of Raymond. Oh, he was quite a brilliant engineer.
Did Pat Brown himself get involved very much in the case?
Not really. I remember him coming through the office up in San Francisco during the trial on several occasions, and he was very humorous. He came in, he talked to me and shook hands and, chit-chatted, and it was real, as he always was, the impression I had, real politician, man of the people, and I mean, so unlike his son, who I met later, who, when he was practicing with Bill Norris's firm in Los Angeles for a while. Jerry Brown was there. He was always kind of a very serious, got not much light-heartedness in Jerry, unlike his dad.
Um, were you all assigned to work on different issues?
Well, we had an overall strategy. We knew what the issues were that had been identified that we're working on. I think as a young lawyer, I got to do a lot of research on different issues, and at one point I was assigned these two boundary cases, the Fort Mojave and Colorado River boundary disputes, because there was a fair amount of water involved, and so Mike and Charlie Corker gave me that assignment, which was good for a very young lawyer. I put the whole case together and tried it and everything, so it was a big thrill for me and good experience. I probably would have never gotten anything, that kind of experience, that soon after graduating from law school as I did working in the special Colorado River unit. I think they would parcel pieces of research out, but Charlie Corker and all the people I mentioned pretty much zeroed in on particular issues. For example, John Alexander and Harry Sondheim did most of the research on the Indian water rights issue and the reserve rights and so forth. I did a lot of work on the legislative history of the Boulder Canyon Project Act. Mike, of course, would do the outlines of briefs and make the strategic decisions, which the other council would go along on about how we were going to treat these issues. But certainly issues on the compact, meaning we all thought at that point that the compact somehow was relevant to the litigation, when the special master disagreed with that ultimately. But Mike and Charlie would decide how we were going to attack these issues, and then they might make assignments to Bert Gindler, Howard Friedman. They were a little more senior than I was, and I'd get different pieces to work on. But and then Shirley was hired, as I say, and Bill Norris were special targeted issues. They might hire specific lawyers on a contract basis to work on issues that they might need rather speedily, or they thought those lawyers might have some special expertise on. But I think all in all the personnel were used quite efficiently. It's my recollection that the in many cases, Metropolitan would sometimes file an independent brief and sometimes Imperial, but by and large, most of our efforts were kind of joint briefs that everyone would join in. And I don't recall that, maybe beyond the contributions Harry Horton made, and to a lesser extent Jim Cooper, that we ever got much in the way of work product from the agency. Now, of course, when we put on our affirmative case, eventually, we all thought it was an equitable apportionment case, so we thought we had to prove our water rights. So, of course, Frank Jenny put on the Palo Verde case, and Harry Horton put on the Imperial case, and Jim Cooper, Metropolitan, so forth. So when the individual agency cases were put on with respect to their water rights, whether they were state water rights or like Metropolitan contract water rights, then the agency council took the lead. But I'd say everything pretty much beyond that was under the direction of Mike and Charlie and Gil Nelson technically, and the work assignments were spread around the lawyers and the special units. So to that extent, I don't think the agency lawyers made a particularly large contribution to the broader issues.
Tell us about your Arizona counterparts.
Oh, see, I'm trying to think. The Arizona started out with a particular lawyer. I think his name was Black. It may have been the Black who later went on to be a Yale law professor, or had been a Yale Law School professor. But he was representing Arizona in the early stages of the proceeding, representing the state of Arizona. They had the same agency problems as we did, because you had a number of Arizona irrigation districts who were involved, and some of whom had water rights in the the mainstream, like Yuma and Welton Mohawk and some of those agencies. But there was one lawyer, very able, I can't remember his first name, but his last name was Black. And in the sometime in the early stages of the proceeding, he came up with the theory that this was not an equitable apportionment case along the traditional lines of those the Supreme Court had decided in the past, but that it was really a unique case in which the contract should control everyone, the three states, at least water rights. And it's my recollection that that was such a radical proposition that and he didn't he didn't want to rely extensively on a traditional equitable apportionment case where each district would present its evidence of its water rights and needs and things of that sort. And I think that so alarmed a number of the counsel for the districts and maybe even other counsel for the state that I believe he was fired. Actually, and they brought Mark Wilmer in from Snell and Wilmer now, I guess is the name of the firm. And Mark came in, he was a very prominent trial lawyer. I don't know if he was a water lawyer, but he pretty much reverted to the traditional presentation that would be made in equitable apportionment case. But as it turned out, later on, it's my recollection, as we got to the final briefing and everything before the special master, he reverted back to the contractual allocation theory that his predecessor had been fired for espousing. And as you know, that turned out to be the winning rationale before the special master. Everything we did in the way of what we thought were all the supporting evidence we needed to show an ironclad priority for the California users under traditional equitable apportionment principles were just ignored by the special master and the Supreme Court. And the special master and the court ultimately held that the Congress had authorized the secretary to make a contractual allocation among the three states, and that in fact he had done so by all of our water delivery contracts. So,
Tell us about the special master.
well, special master Simon H. Rifkin of Paul Weiss Rifkin in Garrison, New York. Well, he wasn't the first special master. Before I came to the case, the suit was filed in 52, and early on, I think the defendants, the California defendants, moved to join the Upper Basin states. And about that time, the Supreme Court appointed a special master named Haight, H-A-I-G-H-T. It may have been George Haight. And he decided, as I recall, the so-called joinder motion, and rejected the idea that the Upper Basin states were indispensable parties for this lawsuit, and a number of them had not intervened. So we hoped, I think, I wasn't there at the time, I think the hope was that the suit would go down the tubes because of the indispensability of those Upper Basin states. But he rejected that argument, so did the Supreme Court. And then he died shortly after the joinder decision. And I think Rifkin probably was appointed about 1954 or 55 and came on. And as I say, they had some pretrial hearings. This was before I was involved, but beginning in the summer of 1956, he scheduled the trial for San Francisco, and that's where we tried the whole matter. He was a prominent New York City lawyer, not with no familiarity with water issues or anything, and he had been a federal district judge and retired sometime, I think, in the early 50s, because he said he had, as I recall, as I was told at least, he had a lot of children in college and so forth. District judges didn't make much money then. He wanted to get in private practice, which he did. But somehow he was very well respected in the bar, and someone at the Supreme Court obviously thought highly of him and appointed him special master, as I say, about in 55. He was kind of a somewhat arrogant man. He was never in doubt about himself, and he and Mike Ely would often, kind of two of a kind, they would often have little exchanges in the courtroom. But Rifkin was very brilliant, obviously very brilliant, always cut right through the heart of the issues and everything. But as I say, he was never in doubt as he moved along and so forth. And he conducted the hearings very expeditiously and I think very fairly and effectively. He would often sit with his, we'd be in the courtroom. The trial was held in I think it was the then post office building up in San Francisco, just off the corner of Market Street, about maybe 9th and Market. And we had a big room there that they made it. It's either a federal building, I believe it was a post office. And they made this big room available for the trial. He'd often sit in his swivel chair up on the platform with his back to all the lawyers as they would be doing their direct and cross examination, and you always wondered whether he was asleep or whatever. But he would, in critical times, he'd spin around in his chair and inject himself. But I always thought that was quite amusing. Like he was
unnerving.
Yes, he wondered whether he was hearing any of this and so forth. But he was a small man, and maybe that was part of what shaped his personality, because he was very aggressive and very intelligent, and everyone certainly respected him, and he was highly respected in the legal community in New York.
And he had a law clerk, right? Or at least not a law clerk, but he had someone to assist
the
him.
law clerk. The first one I remember was Charlie Myers, who later became part of the Stanford faculty and later dean, became a very good friend of mine. But I met Charlie during the course of the proceedings for the special master. Charlie had been a prominent oil and gas lawyer down at the University of Texas Law School. And then he moved up to Columbia. And I can't recall what Charlie was teaching. I doubt if he was teaching oil and gas law up at Columbia, but he was teaching somehow. Charlie never told me how he got hired by Judge Rifkin to be his clerk, but I'm guessing that Rifkin wanted to get some sharp young professors to help him, and he may have just made an inquiry at Columbia. Maybe Rifkin went to Columbia, for all I know. But he hired Charlie, and Charlie was the mainstay of his staff. He was his principal clerk. Toward the end of the trial, he brought in another lawyer from New York, who I think was a member of his firm, Paul Weiss Rifkin Garrison, a fellow named Fishbein. But other than that, I don't think that Judge Rifkin had any other clerks. But Charlie was very effective. He'd come out with the judge, and of course he'd do a lot of the work in the interim periods between the hearings for Judge Rifkin, and was a brilliant guy. And when he finally moved out to Stanford from Columbia, I'd say in the 60s sometime, and then stayed on there as they became dean, and then left Stanford and went with the Los Angeles firm. Was Gibson, Dunn and Crutcher in their Denver office, and was appointed special master in the so-called Pecos River original action in which New Mexico had sued Texas. Charlie did a very good job, and then he died at a relatively early age, I'd say about 1990, from pretty much lung cancer and heart problems associated with it. He was a voracious smoker. I mean, you were really smoked out if you were spending any time with him. So, a word of caution to smokers. But that was his principal clerk, and as they say, Fishbein came on to help at the end. But I'm guessing Judge Rifkin probably had some of his associates in his law firm do, research for him and more mundane things. But Charlie Myers was his right arm, pretty much.
And the U.S., who represented the U.S.?
Well, we were just talking at lunch here we're in the pavilion because let's see, there was a couple Arizona lawyers there, and Mike Clinton. We were talking about Bill Veeder, the notorious Bill Veeder, who had been in the U.S. Justice Department. He was the original lawyer representing the government when Arizona filed the lawsuit in 52. And he had also been he also at that time was a government lawyer in the so-called Fallbrook case, where he made the outrageous assertion that the federal government had some kind of paramount, as I recall, authority over all the water in the West, and they could do whatever they wanted without regard to state law or anything. And that was in the early 50s when the Eisenhower administration took over in 1953. Veeder was fired from the spot as the government's lawyer in Arizona against California and shipped over to the Bureau of Indian Affairs. By and large, he was kind of sent to Siberia because his view of federal supremacy and water rights was not one that found any favor at the Justice Department. Although it's strange that the ultimate victory Justice got out of Arizona against California was an all federal rationale. But the two lawyers that took over were Dave Warner and Walter Keachel. And they were, I think they were both from Nebraska. And they were proteges of the Solicitor General at the time, whose name was Rankin. And when he took over as Solicitor General at Justice, he brought Dave Warner and Walter Keachel in from whatever, I think they've been private practice in Nebraska, and they really ran the litigation with help from individual Interior Department lawyers. The client, of course, was the Secretary of the Interior, and the agencies there, the BIA and Bureau of Reclamation and so forth. And those two justice lawyers would often have assistance from those Interior Department lawyers, but they were both very staid, kind of conservative lawyers. Dave Warner talked very slowly, and if you were sitting in a summer afternoon up in San Francisco when he was examining the witness, why you might well doze off because Judge Rifkin would often have to try and let's move it along, Mr. Warner, and Keachel was more dynamic and a little more feisty. Then Warner was very placid and, as I say, stayed. Keachel was kind of more aggressive and active, and Mike Ely used to get under both of their skins. I mean, they'd be, presenting direct testimony by a witness or cross-examining, and Mike would always be coming in with little kind of nitpicking objections or needling them because he knew he could disrupt them, and Warner would get flustered a little bit, but kind of maintain his cool, whereas Keachel would get all kind of feisty and fire. And Walter is still alive. I see Walter periodically, and he called me after our oral argument in Arizona against California in April of whenever that was, 2000, I guess. It was too young. And they, you would not have thought that they would have been able to put together the amazing victory they did in the lawsuit, but they did, and they were good lawyers. They had good pedigrees from law schools, and Keachel went on later on. Dave Warner, I think, retired and died at an earlier age, as they say. Walter's still around, but Walter stayed on for some time. Then he became an environmental lawyer for international papers, something I see him periodically at the American Bar Association Water Law Conference down in San Diego. But those two guys pulled off a major victory for the government.
Now, at this time, the Indian reservations didn't have separate representation as they've had in subsequent iterations of the case. Right?
No, that's right. In fact, I think first of all, the Navajo tribe tried to intervene, and they were denied intervention. That was Norman Littell, who was a very prominent Washington lawyer, representing a lot of Indian tribes. They never got into the case. I don't know that anyone else ever tried to assert the right to represent the tribes independently. That was kind of a transitional period. The law had always been that when the government is in a case involving Indians, why the Attorney General has complete authority, whatever he wants to do is binding on the government and on the tribes. Somewhere along the way, as a matter of policy, I think the United States decided to let the tribes, if they wanted, to have their own independent council and to try and help them fund that council to some limited degree. And so that's what has evolved today. And as you know, in Arizona too, each of the tribes had their own independent council. And now in the final stages of the dispute down the Fort Yuma Indian Reservation, they have their independent council. The government is also there on behalf of the tribes. It's sort of in a backup role. The government lawyers, justice lawyers, and the tribal lawyers really have to reach agreement. And I think by and large, unless there's some outrageous position that a tribal attorney would want to be taking on an issue that would be prejudicial to other Indian claims or to the government's interest in the subject matter, why they pretty much defer to the council the tribes have hired. That's what's evolved over the years.
Tell us a little bit about how Rifkin's opinion came to be. I think there was a draft at one point, and the parties were allowed to comment.
That's right.
And then a final. Now, were you all surprised by the draft opinion, or did you kind of have clues along the way?
I don't think any of us had a clue that the draft opinion was going to be the way it was. I remember when it came out, I think it was dated December 5th, 1960. Or maybe that was the final opinion, but the judge said he wanted to give us a draft opinion. And he told us then we would get a chance to comment on it, and he would prepare a final opinion. I can't remember whether it was the draft opinion or the special master's final opinion. I kind of think it was the final opinion that Mike Ely sent me up to York, Pennsylvania, where it was being printed, so that as soon as it came off the press, I got a box of them and drove them back to Washington. But the draft opinion was a complete shock, I think, to everybody, because we were so convinced. Californians were convinced, and Nevada was convinced, I think, but Arizona was taking a long shot. We were so convinced that the case would be decided on traditional principles of equitable apportionment, and we had put in a good case about our senior water rights and the magnitude of them, and we had put in, the court had indicated in earlier cases that available water supply would be kind of matched against requirements of the states, and that would be a factor. So we had all this evidence we tried to put in that about water supply, but we did put it in. We had a voluminous record. It's just that in the draft report, the special master said it was all irrelevant. Everything we had proved about our water rights was irrelevant because Congress had in fact authorized the secretary to make a contractual allocation of the waters of first 7.5 million acre feet of the waters in the mainstream of the lower basin. That in fact he had done so through the Arizona and Nevada master contracts and through the collective individual contracts with the California agencies, and that was the allocation. Well, and of course he bought 100% all the government claims for Indian tribes, and that was the first time the magnitude of Indian claims was set at practically irrigable acreage. We all knew of the Winters Doctrine and that there was such a thing as an implied water right for Indian reservations. But the magnitude had been determined under a number of different formulas, and California argued for giving the tribe the maximum amount, each tribe the maximum amount they had ever used on the reservations, plus some modest kicker, maybe another 10 or 15%. And Arizona argued that the decree ought to be left open, just give the tribes what they're using now, and if they ever need more water, they can come in later. But the government asserted that it would be best for the tribes if you took a look at all the practically irrigable acreage on the reservation and gave them enough water to satisfy those requirements, and then each reservation's need would be determined for all time. They wouldn't have to come back to the court. Everyone would have certainty as to what the magnitude of the rights were. And we were surprised we weren't as much surprised by that because we knew that the government had been arguing that, but the idea of the contractual allocation, which the government picked up on too, so they were kind of siding with Arizona's initiative on that. But that just stunned all of us, and we really tried hard to get that turned around. We were given a chance to comment on the draft report. We wrote official comments to the special master. Then we had 2 days of hearings before him in New York at the federal building, the federal courthouse in downtown Manhattan. And he may have changed a few things in the draft report, but not much, only things to kind of correct minor errors he might have had. But the fundamental principles of his report weren't changed at all.
Now, what was the reaction of the California clients, so to speak?
Oh, well, I don't know. It's, I remember Mike Ely gave a speech at what was then called Town Hall in downtown Los Angeles. I don't know if that group is still around or not, but I helped, I mean, I didn't conceptualize the speech, but I helped work on it and everything. And I think on that, I always remember this, Mike in a way tried to characterize it as a victory of some sort for California, which was, I think, quite a stretch. But I think everyone was shocked. You couldn't say we had, the case had not been strategically well planned or implemented. I think we had a wonderful record, and our briefs, I think, were great. If you just think about the way the Supreme Court's final decision came down, which was what, 5-3. When you got justices like Justice Douglas and Justice Harlan coming down on our side, and two philosophically different justices by about 180 degrees, I think you read that dissent, they were right on target, and I think that's the way everyone thought that case should have been decided. It was pretty startling to us. I heard later, by the way, might be interesting, but Mike told me that, we had the oral argument before the Supreme Court, and it was the longest one on record at that time, I think, except for maybe the civil rights cases, but it was like 16 or 17 hours. And then they recessed for the summer, I guess, and then over the summer, 2 justices retired. I think it was Frankfurter and maybe Burton, I can't remember. And they were replaced by, I believe, Goldberg and Byron White. So when they reconvened in the fall, they rescheduled oral argument because they had 2 new justices that would replace the 2 retiring justices. And we had something like 9 additional hours then on reargument. And Mike told me once that Frankfurter told him that after the first argument, when the court went back in and did their straw vote, as they usually do, about how they see the case, that California had prevailed 5-3. But with Frankfurter and Burton retiring, White and Goldberg came on, and they went in the opposite direction. So the ultimate decision was against us on a 5-3 basis. So it's just such a quirk of fate that the timing was such that the decision could not have been rendered before 2 justices who were on our side had retired.
Had there been any settlement discussions amongst the parties during the duration of the case?
I don't think there were ever any settlement discussions. I think there may well have been. If there were, I don't remember them getting much prominence around the office. Mike was very convinced of that we had the strong case and were destined to win, and I think everyone else on the case felt the same way. And if there were any suggestions for settlement, I'm sure when Mike talked to Pat Brown about it, he told him he would probably recommend against it. In my later years working with Mike, he was never one interested particularly in settling cases. Mike was a brilliant guy and had a pretty strong ego, and I think he felt that he was correct on most of the representation he undertook for a client. And certainly, if you look at the kind of case we put on that under his direction and measured them against the Supreme Court precedents at the time, it looked like we did all the right things and had an ironclad victory. I think we felt, I remember we used to talk about it, Mike and Charlie and all of us after kind of post-mortem, that we wondered if somehow California might not have been prejudiced by marching into court every day with, Mike and the entourage of state lawyers, and then the 5 agencies with their entourage of their own lawyers. I mean, California lawyers and engineers dominated the space in the hearing room. There was California with Mark Wilmer and a couple other lawyers, and poor Dave Warner and Walter Keachel just by themselves. So it looked like kind of David and Goliath. We were coming in with all the power and the money and everything, and we often wondered whether somehow that influenced the judge in trying to figure out some way that he could help poor struggling Arizona in this dispute, in which led him to think of this unique interpretation of the Boulder Canyon Project Act that he finally settled on.
Did you guys have any idea that your oral argument was going to take, that you were going to be given so much time? Preparing for that oral argument must have just been an enormous task.
Well, I think we weighed pretty carefully, looking at all the briefs and all the issues, and of course that the federal contractual allocation scheme had only been sprung on us, in the draft report. So we had never researched that or were prepared to argue why it was completely off the wall and why you had to take a hard look at water supply. These were all kind of givens before. So I think we made a good assessment of what we needed, and each of the agencies wanted to have something to say. I don't think each agency counsel argued. I'd have to go look at that, but Mike carried the ball pretty much. Harry Horton may have had something to say, and on some of them, maybe Jim Cooper, if they had a unique issue or something. But I think we made a good showing about why we needed so much time, and these were major, major issues, setting a broad new precedent on interstate water allocation, Indian water rights. And of course, there was California, Arizona, Nevada had its case, so you had 3 states in there. And I think we felt we needed that much time. I don't think we were surprised when the court gave it to us. We were surprised, with the eventual outcome, needless to say. We thought from the way some of the questions from Justice Douglas and Harlan came down and the good argument Mike made, I think we were kind of optimistic that we might get it turned around, but we didn't.
Now, one of the outcomes of the case was, of course, then that there had to be this determination or listing of present perfected rights. Were you involved in that?
Well, let's see. The decree, after we had when we had the argument on the draft report for Judge Rifkin, he didn't make any changes. After he drafted I'm trying to think, he gave us a chance to tell him what he ought to do with his recommended decree. I don't know whether he did that when we had the argument on the draft report or whether he had a special session after his final report was out. I think we did it on the draft report. He kind of leaned on us to make sure that the decree was, whether we liked its substance or not, whether we thought it was adequate to take care of the issues the way he had decided them. So then the court handed down its decision in 1963, and the decree came out in 1964. I didn't get involved. I left Mike's office in the end of 65, and even though the present perfected rights were supposed to be decided within several years of the decree, as you know, that dragged on and never really got decided until 1977 because there were a lot of negotiations between the states and the government and the Indian tribes on what the respective present perfected rights were at the time. I think Doug Noble really handled the bulk of that for the state, and I think with contributions from each of the agencies. And I guess Bob Will would have been involved during that period too, in the early 70s when he was general counsel at Met. But I was off then. I'd moved on to the Public Land Law Review Commission, where I was heading up the legal staff, and so I just know from reading and talking with people about what was involved there.
So from late 1965 to about when you really weren't, you had a hiatus from Colorado River Matters.
Beginning, I went with the Public Land Law Review Commission in January of 66. And I stayed with, they were to stay, the Land Commission was chartered by Congress to review all federal land and natural resources policy and come up with recommended changes in policy for Congress and the president. And they were really scheduled to go out of existence in 68 sometime. They had a 4-year life. Well, they got a late start, so they eventually got an extension of time, and the commission didn't wind up until June of 1970. But Wayne Aspinall of Colorado was the chairman, and he asked me to stay on to the end until we had written the report and everything. So I did. I had not planned to stay that long, but I didn't feel like I could bail out in the middle of the commission's effort, which I strongly believed in. It was a challenging, interesting job, and I think the commission did a good job. But so I stayed with the Land Commission until the middle of 70, and then I went to George Washington Law School as a visiting professor for about a year, into 71 sometime. And then I went with another law firm in town, Debevoise and Liberty, excuse me, which was primarily an electric utility firm. And I was not working on any Colorado River matters during that whole period from 66 to about 72 or 3. And then Bob Will talked to me about working on the Fort Yuma Indian Reservation boundary dispute. Sometime, I think it may have been as late as 75, but perhaps in 74 sometime. So that was 25 years ago, and here we are yesterday having a meeting of all the council in Arizona against California, trying to see if we can settle that very same dispute or whether we're going to have to litigate it. So it's hard to believe that on and off since about 75, I've been working on that same boundary dispute, which is the last issue to be resolved in Arizona against California.
I think when most people think about Mike Ely, I mean, he's got to be considered one of the most colorful characters, and of course, having been involved in the negotiations of the early contracts with the agencies and things like that. Did he ever talk about those times and what it was like and how he banged heads or what he did to get people to agree?
No, Mike never talked much about that. Of course, when I went with him, he was so heavily involved in Arizona against California. We really didn't have much time to talk about what he did on the contracts. As most people know, Mike had gone to Stanford Law School, Stanford as an undergraduate and Stanford Law School, and he became very close friends. So Mike was sort of a big man on campus in the 1920s. He became very close to Stanford President Ray Lyman Wilbur. So and Herbert Hoover was a Stanford alum also. So after Hoover was elected, he persuaded Ray Lyman Wilbur to become Secretary of the Interior. Wilbur needed a someone he trusted and would be his strong right-hand man as a lawyer. Mike was practicing, I think he told me, admiralty law or something up in New York City. I think Mike got out of Stanford about 24, 5, 6, somewhere in there, and he practiced in New York for a while. And then, of course, Wilbur became Secretary of the Interior in 1929, and he brought Mike down as his right-hand man. And Mike, as you know, from all the documents that Ken Hutchinson of Met's legal staff put together on the negotiation of the 7-party agreement and everything, Mike had the principal responsibility for negotiating the water and power contracts under the Boulder Canyon Project Act. Mike never talked too much about this. But I know he didn't feel that having done any of that presented any conflict, because it seems to me he represented Imperial in the dispute over the 160-acre limitation, even though he or Ray Lyman Wilbur, at Mike's instance, had written a letter of some sort which opined on the question of whether or not the 160-acre limitation ought to apply to Imperial. And I think Mike, I think, was on the other side when it finally got up to the Supreme Court. But Mike was so involved with all these Colorado River matters, it was hard to imagine in many ways. I don't know what the standard of ethics would have been. It's hard to imagine that Mike could have gotten too involved in litigation, certainly with the government, over the meaning of water and power contracts that he had personally negotiated. That always struck me as a little strange that happened. But anyhow, I mean, he had the wonderful reputation. He had a brilliant mind. I was very impressed with him, naturally. When he offered me a job to come back to Washington, my wife and I thought a great deal about for a long time, because we liked California, where we were after Stanford. But we had our first grandchild of our 2 widowed mothers, and we were on kind of a guilt trip and felt we ought to go back east and be close to them so they could see the grandson and everything. So we did that. Mike said, well, come on back with my firm just for a year or 2, and then I'm going to open an office in Los Angeles to carry on the Colorado River litigation, and you can come back to California and head up that office. So I thought that was a nice compromise. Well, Mike never did open his California office. As it turned out, the Attorney General made a permanent little suite of offices available for Mike down in LA in the State Building, and Mike used the state offices all the time. He never really needed his own office. And we got fond of Washington, so our original plans to come back to California just never came to fruition.
Now, about 1975, then you started representing Metropolitan
Right.
On the Indian boundary
Right.
disputes and the administrative process, I guess, with the Secretary
Right.
of Order on Fort Yuma and so forth. And then you also were retained by Met to start working on some Hoover energy
Mm-hmm.
issues, the renewal of the Hoover power contracts.
Right.
And my recollection is, I think that Met and DWP, who I think was represented by Mike Neely at the time, were not always quite on the same page on some of the issues on the renewal of Hoover Energy. So that must have been kind of interesting to be
Yeah.
on sort of the other side of the table from your former mentor.
That's right. Well, Mike had not gotten involved at all in the Keishan Fort Yuma matter. Just mention that, excuse me, a moment, because it was so interesting. I assume it will all come out in discovery, and if we have to litigate the Keishan claim. But what had happened is that in the in Arizona against California, the government had made a limited claim for the Fort Yuma Indian Reservation. There had been a boundary dispute years before. The Secretary had determined that some 25,000 acres of land were not part of the reservation in 1936. And based on that decision, during Arizona against California, the government only made a claim for the other undisputed lands in the reservation. So in 63 and 64, we thought that was the end of the case. Beginning in the early 70s, the tribe persuaded the Klepi administration at Interior and the solicitor over there at the time to take another look at that boundary dispute and reverse the earlier 1936 so-called Margold opinion. That moved down along the tracks very speedily, and was state parties in California and Arizona were given a chance to comment on that proposed reversal, and they objected to it, but they didn't feel like they had an adequate opportunity to make a good record before Secretary Kleppe. So Bob hired me to prepare a pretty comprehensive set of arguments to present to the new solicitor. We got an extension of time to do that. So I did that, and then Congressman Rhodes, who was, I guess, then the Speaker of the House, influential Republican, demanded that Secretary Kleppe give the affected water users a chance to explain why the earlier opinion should not be overturned and be indeed affirmed by the Kleppe administration. We had a one-day hearing. We all sat around the room back in Interior and made arguments before Secretary Kleppe and Solicitor Austin. And the next day, the tribe came in and made their arguments. And Solicitor Austin decided that he would not carry through with the proposed reversal of the earlier Margold opinion, but that he thought it was correct. The tribe prevailed on Senator Jackson, chairman of the Senate Energy and Natural Resource Committee, to hold some oversight hearings on what had happened, and there were a number of Indian sympathizers, both among the Senate membership of the committee and certainly on the staff, and they leaned very heavily on or complained very heavily to Kleppe and Greg Austin, the solicitor, about what he had decided. So Greg thought he would write a formal solicitor's opinion to lay out his reasoning, which he did, and he filed it in January of 1977. When the new Democratic administration came in with Secretary Andrus and his new solicitor, Leo Krulitz, the tribe renewed its efforts to get, now they had to get Margold reversed and Austin reversed, and they prevailed on the solicitor to do that, and he did reverse the earlier solicitor's opinion, held that these disputed lands were part of the reservation.
Who kind of spearheaded the argument for the tribe?
Well, I think, what was the lawyer's name who used to represent the tribe originally? Ray
Simpson.
Ray Simpson. He was their lawyer, and he had a very sympathetic social solicitor for Indian affairs there under Kleppe, and so they didn't have to do much arguing, and they had sympathetic folks in the administration. And then after Kleppe went out, I mean, they had sympathetic lawyers in the Kleppe administration. After Kleppe left, the same lawyers were there, and not the top solicitor, but the underlying associates. And again, the tribe didn't have much trouble in persuading them to overturn that earlier ruling. And as you know, that's where we are now. We're back trying that whole issue, maybe having to try it on the merits, although we hope we'll be able to settle with the tribe somehow. I think we had at least not a discouraging meeting yesterday. I think the tribe's present council may be someone we can deal with. Time will tell. But then, okay, the Hoover Power. Well, Mike had written all the regulations for the allocation of the power from Hoover, the firm power and the secondary energy and everything, and the rates were set under those regs in a way that would recover for the government all the capital and operating costs of the dam for a 50-year period. And then at the end of the 50-year period, when the contracts were up, the secretary was supposed to kind of square the books, and if the refunds, if the power users had paid too much, they would get a refund. If they hadn't paid enough, they'd have to ante up some more money. Well, it turned out there was, when they settled up the books, whenever in I guess, late 80s, 50 years from whenever the contracts were executed. Seemed it was maybe around 1990 or something, but there were $25 million to be refunded. And the question the secretary struggled with, now it had become the Secretary of Energy as opposed to Secretary of the Interior, because power marketing had been moved over to the Energy Department. Secretary of Energy decided to distribute the surplus revenues among just the firm contractors, which, because the firm contractors had really underwritten the project, they committed themselves, Met included, was the biggest purchaser of the firm. Power had committed themselves to pay for enough power to fund or to recover the cost of the project, whether they used the power or not. And indeed, Met paid for a fair amount of power it never used in the early years. So the formula the secretary came up with was one that Met and the Arizona Power Authority and the Nevada Colorado River Commission, I guess, liked. The other firm contractors were LA Department of Water and Power and Southern Cal Edison, or whatever it's called now. And they didn't like the formula because they thought they should have gotten more money back, that the overpayment should have been returned dollar for dollar to those who paid them. And Mike was representing LA Water and Power. And again, he had been heavily involved in writing the regs that we were litigating the meaning of. And again, I was a little puzzled by that. But anyhow, Mike died during the litigation at the age of, I think, 92. Died with his boots on, right in his office, and I think he was working on this Hoover refund case. But anyhow, we prevailed on that. We prevailed. Well, we didn't prevail completely before the Court of Federal Claims, but we won most of what we wanted. And then we didn't like a part of the Court of Federal Claims decision in LA, and Edison didn't like any of it because they didn't get much, if at all, if anything at all. And so we took it up to the Federal Circuit, and they reversed the part of the Court of Federal Claims, the decision that Met and Arizona and Nevada didn't like. So we ended up keeping all of our refunds, which may have been $9 or more million out of the 25, I can't recall. But anyhow, that was interesting. And I think we made a little bit of new law in the Federal Circuit back there on the way regulations, the Secretary's interpretation of regulations is to be treated in a suit for breach of contract, which is essentially what Edison and LA brought. They claimed that the Secretary had breached their power contracts. And we said, no, the power contracts incorporated the regs. Secretary was given broad discretion in the regs, and he exercised it reasonably, and that ought to be the end of it. And the Federal Circuit agreed. So that was a good win for the part of the firm contractors.
Did you also do some work from that on the renewal of the Hoover Power contracts?
Oh, that's, in the early 80s when the contracts were coming up for renewal. I think, well, at the time, I was doing work for Met, remember, in Arizona too. Not quite as visibly as later on, but when the government and the tribes filed in 1970, December of 1978, to reopen the decree in Arizona 1 to award water rights for so-called omitted lands that they hadn't claimed water for, and for disputed boundary lands. Carl Barranque, who was, he was not, let's see, I guess Carl came out a little after that. But anyhow, Carl had me do a lot of work on the briefing of that case. And then, as you recall, companion lawsuit was filed in San Diego. And I helped you and Warren Abbott, I guess, on some of that briefing. So I was working throughout the early 80s in Arizona too, but I I wasn't listed on the early briefs because Carl, nor was Carl. Carl had been at the State Department of Justice, California AG's office, and I had had that short period of 6 months as a deputy attorney general when I started right out of law school. And there was someone in the California AG's office that said they didn't think it would be appropriate for Carl and me to participate on behalf of Met, because Met might get into a conflict with the state on some issue, and since we had worked for the state for some period, it would be, they thought, maybe a conflict. Well, Carl and I sort of just went into the background for a while, and I didn't do anything. And then the administration changed, and there was a new attorney general in California. I can't remember who it was, but they said, forget about it, there's no problem. So then, I think toward the end, my name was on some of the briefs, and Carl was taking an active role. Of course, he had become general counsel at Met by then. But in the same period of the early 80s, the Hoover power contracts were coming up for renewal, and I worked, I guess, with Fred Vending on doing a lot of briefing on why our contracts ought to be renewed and why the restriction on the restriction requiring us to use our power just to pump water into and in the aqueduct ought to be stricken. So I did a lot of briefing administratively on the administrative proceedings, but then they wound up and some lawsuits were filed, and Nevada and Arizona asked me if I would be interested in representing them in the litigation. Well, Carl hadn't asked me to help in the litigation at all, so I talked to him about it. And he just said he didn't want me to represent either Nevada or Arizona. And I said, well, are you going to use me for Met? And he said, well, I don't know, but he said maybe or maybe not. And I said, well. So he decided the fair thing to do was to put me on a retainer, so that since he didn't want me to work for the other states and wasn't sure how much I could be involved on behalf of Met, at least I'd be getting some compensation for having foregone working for the other states. So that was in the early 80s sometime. That was the basis of my retainer, which lasted until just a few months ago. And now I think, I'm treated like all the other lawyers. I'm just on an hourly basis. But I think Carl felt that in Warren later it was good to kind of keep me on a retainer so I'd be around to help on anything that they wanted.
Now, did you get involved in drafting the legislation on the Hoover renewal contract? Eventually there was federal legislation.
No, I really
on
didn't. That was pretty much all Bob Will, and I think Eddie Weinberg for Nevada and Bob McCarty for Arizona. No, I didn't. Somehow or other, I was out of the loop by then. We had filed all our administrative comments and so forth, and I think the lawsuit had been several lawsuits had been filed, and I was kind of on the sideline at the time on those, but I didn't do any of that legislative drafting.
Now, at some point in time, you partner up with Bob Will.
Right.
And you form your own law firm, and Bob continues to do a lot of lobbying, representing different agencies, including the Colorado River Board, Metropolitan, and things like that. One memorable piece of legislation, I think, the All-American Canal Lining legislation. I think you
I did work on that.
participated in that to some extent.
Well,
remember about that?
That's how we got Bob and I got together. Of course, I knew Bob. I had met him when he was just on the legal staff at Met, at some point over the years. And then when he came back as Met's lobbyist, I got to know him better. And then after he left, we came back as Met's lobbyist, and then he went back to Sacramento as Met's lobbyist in Sacramento for a while, and Jerry Butchert was back here, and I think maybe even Ron Gastelum for some short period. Ron had been on Bob's legal staff for a while, went off somewhere else ultimately. But then Bob came back to Washington, not as a Met employee, but as I think he had retired from Met and he was just in private lobbying practice. And of course, we saw a lot of each other, and he worked on lobbying matters like drafting the Hoover renewal legislation, and I was working in Arizona against California and boundary disputes and some of these other legal issues. And about 1987, we were in the middle of the San Diego litigation over the boundary disputes, and I was running the Washington office of Holland and Hart, which was a Denver law firm. And the counsel for one of the tribes wrote me and said that he thought I should be disqualified from continuing to represent Met in the San Diego litigation, or if we went to the Supreme Court, because one of my partners in the Denver office of Holland Hart was former solicitor Greg Austin, who had written the 1977 solicitor's opinion, which was favorable to our view of the proper boundary of the Fort Yuma Indian Reservation. Well, I had talked to Greg Austin about that when he came back to Holland and Hart, and he never had recalled working on any of the boundary disputes, but he checked his files, and lo and behold, Scott McElroy, the counsel for the Colorado River tribes, was correct, because Greg had signed some papers during the present perfected rights negotiations and everything, supporting the tribe's claims. So I either had to leave Holland and Hart or give up Met as a client. So I left Holland and Hart because the state of Colorado at that time did not permit kind of building a wall between lawyers in the firm and partners who had been in government service, so you would be insulated from conflicts. They didn't have that kind of liberal rule. They do now, but they didn't. So I left. I decided I had to leave Holland and Hart, and I was just tired of big law firms. That was the only big law firm I'd ever been with, and of course I'd been with Mike, and we never had more than half a dozen lawyers. And that's the phone in the background. Bob and I were working together on so many things that we thought it might make sense to form a partnership. So we did in '87, and that lasted until '94, when Bob said he told Gene he was going to retire to San Diego and retire from active lobbying. They moved to San Diego, but obviously he hasn't retired from active lobbying. He's still back in Washington a couple weeks a month, but we still see each other a lot. But that's how we got together.
Now, one of the things that you worked jointly on, though, was the
legislation
on the All-American Canal.
That's right, and we're trying to figure out at the time, trying to think, was Warren Abbott general counsel then? Because Carl and maybe Carl was general manager then, but Myron was working on it.
Right, so I think that means Carl had to have been the
Yeah, he was general
because
manager.
he hired Myron to come
That's
up with
right.
the map.
They were trying to figure out, where I got involved was, they're trying to figure out how they could divide the conserved water that was going to be made available by lining the All-American Canal, because you had the 7-party agreement. And obviously the ag users felt that if water was conserved, it ought to flow down through the priority system, even though Met might have paid for it. So I guess my assignment was I wrote most of the language used in the committee report, justifying, sort of giving anybody in any of the California agencies a first crack at paying for and getting the surplus water, but if they didn't, permitting Met to get it. And I think that we had a good basis for that. I think we probably could have gone further, and Congress could have actually superseded the 7-party agreement, said, well, we don't care what the agreement says, we're going to give the water to the party that pays for it. Anyhow, And also, as you know, Imperial got the first option to do the job itself, which was a concession that Met made, and to Imperial, and Met made a few other concessions, I think, to Tom Levy about what Coachella's rights might be in the surplus water. But that turned out to be, that language giving Imperial first option turned out to be kind of a stumbling block for a while, and I think delayed culminating some reasonable agreement for lining the canal and allocating the water. But yeah, we did. I thought we had some good legal basis for what Congress provided in All American Canal legislation.
Now, you also have had the honor of being appointed by the Supreme Court as a special master in a water case. Did that, working as a special master then, and then being in a different, give you a different perspective of the Supreme Court and how it works?
Well, yeah, I never knew, for example, how special masters operated, and I guess one thing I always like to tell, and I'm sure I told you this a couple of times, about how I got the appointment. I was sitting in my office in Washington one snowy day, and I was the only lawyer in there, and my secretary was the only secretary there, and she buzzed me and said that Justice White is on the phone. And I had been working on a cert petition in another case, and I talked to a couple of my friends about how I had to get around a decision that Justice White had written, and if I was ever have any chance of getting in the court on the cert petition. So I thought, well, which one of my friends are calling me now going to give me a bunch of malarkey about this is Justice White and don't waste your time filing for certs. Anyhow, I answered the phone. I said, yes. And he said, yes, this is Byron White. I said, oh, kind of skeptical. And he said, we get these, remember he said, we get these pesky interstate water cases up here. And he said, I understand from some people that you know something about interstate water issues. And he went on a little bit, and he said, I'd like to talk to you about whether you'd be interested in that. I thought, I couldn't recognize the voice as any of my friends, and I said, is this really Justice White? He said, well, yes. And so I said, oh, well, excuse me. And so then we went on, he said that I had been recommended by Charlie Myers, Judge Rifkin's former clerk, and that if I didn't have any conflicts, why he'd like me to send my resume up and consider whether I'd like to do it. So I checked out, and I didn't have any conflicts. I thought I might have one conflict. I had contributed when I was with Holland and Hart to kind of a partners slush fund for political candidates, and one of them had been the then governor of New Mexico. And the case that Justice White was talking to me about was Texas and Oklahoma against New Mexico. And I thought, well, it might look not right that I'm maybe, if I get appointed special master and someone says, well, look, this Jerry Mize gave $100 to the governor of New Mexico, so forth. So I told White about that, and he said, you mean you gave $100 to go to a cocktail party for the governor? I said, yeah. I said, it came out of the firm's fund and so forth. And I said, I've never had any contact with him. He said, well, if it doesn't bother you, it doesn't bother me. So he said, just forget about it. So that's the way it started. And then as we move along through the case, if I had questions, I'd call the deputy clerk, and sometimes I'd talk with Justice White directly. But I guess the main feeling I had about the whole episode is how much more fun and satisfying it is to be in a quasi-judicial role, actually deciding something, rather than just being an advocate on one side or the other.
Okay, go ahead.
Anyhow, I like that judicial role much better because when you're representing a client, no matter what you think may be the optimum, most equitable solution to a problem, you're committed to making your best effort for your client's position. And sometimes you may not feel completely comfortable with that or whatever, but when you're in this judicial role, though my decision was just a recommendation to the court, you have the opportunity to move things around and kind of affect a compromise that you'd like to think keeps everybody relatively happy. So that's what I liked about it most. I'd like to do it again sometime.
At that time, was Justice White, for some reason, was he in charge, so to speak?
He was in charge of
finding
picking,
special
yes.
masters, or-
I think so. I think he had that assignment because he had picked Charlie Myers, and then he had picked Owen Open to handle the North Platte reopened decree in Nebraska against Wyoming, which, by the way, they just settled a few weeks ago. The Supreme Court approved the settlement in that case. And then Charlie had recommended me, so he called me. So White had picked the three of us in over a couple-year period for the three water cases that had come up to him.
Now, as a special master, after your report goes up to the court and the court comes down with a decision, do you have any more contact with the court? I mean, do they call you and thank you for your service, or?
No, well, usually the final decree says something like the decree is entered with special thanks to the special master, but somehow I got shortchanged. My name wasn't even mentioned in the court's opinion in Texas and Oklahoma against New Mexico. I looked at other decisions sometime. They don't always mention your name. Maybe it depends on who's writing the opinion. Maybe they don't think it's appropriate to mention that Joe Dokes was appointed special master. They just, some of the cases, as did mine, say a special master was appointed. So if you're intrigued about who the special master was, you just go look at the order they cite for appointing special master. But no, I've talked to the deputy clerk of the court quite a bit. We're kind of good friends, and sometimes I ask him about other cases that are pending up there and so forth. But no, I never. The only acknowledgement I ever had that I was even working on the case, other than talking with Justice White, if I had a problem, was I was at a reception up there for something other, and I saw Justice Scalia, who I had known for a number of years. When I was with the Public Land Law Review Commission, he was a rookie law professor down at the University of Virginia Law School in the late 60s, and I was supervising a contract study down there, and I got to know him fairly well. And then later, he was chairman of the American Bar Association's Administrative Law section. The same year, I was chairman of the Natural Resources Law section, so we worked together a fair amount. So we got to know each other. We weren't bosom buddies, but good acquaintances. And I saw him up there and at a reception. He said, "Well, I see we finally got you working for us." And I said, "Yeah, I appreciate the work." That was about it.
Well, as you look back on 30, 40 years of involvement in one way or another on Colorado River matters, what's your most memorable moment?
Well, it was all very challenging and fast. And first of all, it was great to work with an intellect and such a good advocate as Mike Ely. Mike, as many people know, did not have much success with his law firms. He had kind of a 19th, I'd say not even 19th century view of how law firms ought to operate. Mike was a senior partner, and all the rest were. He never had a view of partners kind of sharing the firm. So that was something that I was not happy with. But working with him, I mean, I think it was invaluable, and to see him in action and see that mind at work and what he accomplished, I think that's something I was. He was really a good mentor for me. So I think out of all this, having worked with him made me a far better lawyer than I think I would have been if I would have. I thought for a while about going into some of the big firms in LA. I had offers down there and up in San Francisco when I was getting ready to graduate, but I think I would have ended up, doing some menial, rather non-interesting work. And I just love working in the natural resources field. I guess what I use my Colorado River experience for in most cases when I'm teaching students I've taught for a long time down at UVA. I hope to resume teaching water law down there next year, University of Virginia, is that I always cite our experience on the Colorado as evidence that litigation really doesn't produce very much. I mean, we've been at it 50 years now on the Colorado, and it hasn't produced one more drop of water. And I think if all the time and effort and money and dedication, everything that went into all this litigation had been focused on trying to figure out some equitable settlement with Arizona at some point, why it would have been much more productive. And so that's why when I was special master, the states of Texas, Oklahoma, and New Mexico were so antagonistic, and there was never when we started out, there was never any hope of getting them to agree to anything. And later on, when we got when my report was approved by the court, they remanded one issue to me that I hadn't decided. I was able to work with them and get them to settle that issue, and they all were very appreciative. All the council thanked me, and I think that was, that was kind of a legacy from my Colorado River experience, that continually litigating issues is not the way to solve questions about how to share a common resource like water.
In a few minutes, Sherry, we're going to go downstairs and hear a panel that's going to talk about their vision of
That's
the
right.
Colorado River in the future. What's your vision? I mean, if you look out 10, 15 years from now, I mean, there are so many issues, as we know, that are at a crossroads as we speak. Things could be very different in 10 or 15 years.
Well, I think we will, of necessity or just through belated awareness, come to have a different view of how to manage resources. Over the years, I used to be convinced that, allocations, quantitative allocations were important and you protected them, and certainty and everything was critical. But I like the idea of having a more flexible system of some sort. I think I spend a lot of my time when I get asked to present papers on talking about new institutional arrangements where all the parties will get together. If there are interstate issues, where not just the states will get together, but the Indian tribes will be represented on some kind of a management entity, and that rather than trying to live with outmoded elements such as the compact on the law of the river and so forth, you'll have something like adaptive management. You'll have certain equitable principles that all the parties agree on about what to do in times of shortage, and how to make fair allocations about higher value uses and things of that sort. So I think it'll be inevitably a much more cooperative kind of, in a way, sacrificial management that doesn't rely so much on individual states' rights and what their entitlements should be. The region will be viewed as a region, and what's best for the region will determine how the water is managed. And if certain parties give up rights or equities, they'll be compensated in some fashion or dealt with fairly. And I think that's what we have to come to in the long run. Probably not in my lifetime.
Well, I don't know. I've been sitting here thinking I'd really like to talk to you again in 5 years or so, when I think some of the issues will be put to bed, because there are so many things that you worked on, particularly in your representation of Met, that I think would be great to talk about. I mean, the banking opinions, the discussions with, over the rights to transfer, and working on San Luis Rey matters and things like that. All of those things which are still kind of in the mix, and so not really appropriate for public discussion. But certainly, I mean, I just marvel at all of the people that you were able to work with. I mean, they're really all they're all the names that you read about.
It's all been, an enriching experience for me. It's been a privilege, and as people say, a privilege and a pleasure to have worked with a lot of them, including yourself. We had a number of good years in more recent times working on these Colorado River matters. And I think natural resources work is the most interesting, exciting kind of practice you can have. And I'm so glad that somehow or other Mike Ely led me into it, and I decided to stick with that. I wouldn't trade it for anything.
Thank you very much for your
My
time,
pleasure.
Jerry.
Thanks for talking to me.